People, it's my intent, we've got 8 bills that have to go to finance, and they have to go this week. So 1757, 1452, 1550, 1636, 1699, 1871, 1892, and 2208. All have to go to finance. My intent is to try to get those bills done now. That'll leave us with 26 bills. We'll have to meet at 8 o'clock Monday morning to finish finish our docket. Our first bill, I want to call on Senator Peterson. He's got a civil law subcommittee. No, we don't have to call roll. We've already, we recessed.
All right. This is Senate Bill, I think it's 1757, is that correct?
That's correct.
And this was an amendment to the anti-SLAPP statute, which is 8.01 dash Bueller, somebody?
1757.
Mr. Chair, it is.
I don't have it in front of me.
8.01-22, 223.2.
Okay, this is the statute that basically gives immunity for statements made in a First Amendment setting. And the bill from Delegate Campbell expanded it in a way that I liked. It expands it to all torts as opposed to some specifically delineated torts. It also deals, limits it, the statements that don't qualify for the exemption are statements that are made with actual knowledge of falseness as opposed to constructive knowledge. Here's the one issue. I have my own bill on this same statute. Delegate Campbell has his bill on this statute. We have had some comments from stakeholders, and we're not quite where we want to be. So what I would suggest we do is put a reenactment clause on his bill, which came out of the House uncontested, but put a reenactment clause on it, send it back, and then he and I will go to conference where I also have a bill in the same statute and work it out.
Okay, is that your motion?
My motion is to put a reenactment clause on the bill.
Okay, there's a second.
Yep.
All in favor of that amendment, say aye.
Aye.
Any opposed?
And having done that, move to report as amended.
And refer to
Refer to finance.
Okay. Are there other motions? Please open the roll. Vote yea is a vote to report and re-refer. Okay. You've already left the proxy?
Yep.
Okay. Well, that's one down.
Ayes 10, no zero.
7 to go. Delegate Orrock, you're the only delegate I see here.
Good evening, Mr. Chairman, members of the committee.
Good evening.
Give your attention, please, to House Bill 1452.
1452, Delegate Orrock.
Mr. Chairman, members of the subcommittee, passage of this legislation will put the Virginia Attorney General's office in their Medicaid fraud unit in the same posture as 41 other states, allowing the Attorney General within his existing pool of employees to authorize up to 30 LEO positions among those individuals. They will have to be full LEO trained, full LEO accountability. They will not be a part of Valors. It just allows them to now, when they're exercising their duties, they have to get a local LEO or state LEO to go in to request a search warrant, to execute a search warrant, things of that nature. It will just make it more efficient, and that's all the measure does. It's pretty straightforward, Mr. Chairman.
This would allow him to designate 30 employees of his office?
Of his current 50-some investigators, yes, sir. No new employees, no new FTEs.
Okay, my understanding is that similar bill was introduced in 2012 by Senator Obenshain. That passed out of this committee 8-7, and then was continued to 2013 in Senate Finance. Does anybody have any questions of Delegate Orrock?
Mr. Chairman.
Senator
Or
Serba.
McClellan can go first.
Mr. Chairman, why can't
She
he
can go first.
designate his employees to
Senator
do
McClellan.
whatever he wants them to do?
It's my understanding that we only through code authorize law enforcement entities, and so that's why he has to have that authority. He, on his own volition, cannot just name some of his investigators as LEOs.
Mr. Chairman, when she's done.
Senator McClellan, is that your question? Are you through?
It is, but I don't know.
Okay, Senator Serba.
Thank you, Mr. Chairman. So, I mean, basically, I think by designating law enforcement officers, they get a badge and a gun, and they can arrest people and do all those kinds of things. And I guess only law enforcement officers can execute search warrants. So can you just, I see the bill came out 5047. I don't see anybody looking to stamp to oppose. I'm trying to understand what the nature of the opposition was. Do you have any sense of that? Was there any debate on the floor?
I would suspect you saw quite a number of measures come out that way that in a different context of objectivity maybe wouldn't have gotten the same vote. things have gotten somewhat of a partisan flavor, sometimes I think undeservedly. And I would say, frankly, this is one of them. Because at the end of the day, to your question as to their powers, yes, to be given a badge, but only to enforce the provisions of this article. So it does not allow them to make arrests on anything beyond what they're seeing in a Medicaid fraud situation.
Mr. Chairman, I have a question.
Senator
You
Edwards.
say these are existing people in his office,
Yes, sir.
and that's all?
That's all.
Senator Boysko.
Thank you, Mr. Chair. Is there a big instance of Medicaid fraud going on? Do you have any statistics about how many people are?
May I phone a friend, Mr. Chairman?
Thank you.
We have folks from that office. The key is, these are one of the most successful units in the country.
I would just like to know how they work right now, what investigators they use, what law enforcement they use, and how this would change that.
Mr. Chairman, good afternoon. I'm John Childry. I'm the Chief Counsel to the Medicaid Fraud Control Unit in the Office of the Attorney General. And currently, these are investigations that are going on and have been going on. The Medicaid Fraud Control Unit in Virginia has been in operation for some 40 years. And as the patron mentioned, 41 of the 53 Medicaid Fraud Control Units nationwide, each state has one, and DC has one, Puerto Rico has one, the Virgin Islands has one. 41 of those have sworn investigators. And the reason is fairly simple. These investigations are conducted throughout Virginia, and to do things like swear out arrest warrants, to swear out search warrants, to execute search warrants, we have to partner with other agencies. Well, those other agencies then have to task their law enforcement to help our investigations go forward. And to do that, we are subject to their availability, their timelines, and they get to control some of the crucial timing of these steps of an investigation. Also, these folks that are in sheriff's offices around the state or other state law enforcement officers, they then perhaps have to go to court, and they have to respond to discovery and submit body-worn camera footage. So this would be a help to those other agencies. They wouldn't have to come to us because we're not currently sworn, and we would be able to handle those steps ourselves.
Let me ask you a question.
Senator Edwards.
Y'all still working with the U.S. Attorney's offices? Have an assistant AG working with an assistant U.S. attorney on these cases?
Mr. Chairman, Senator Edwards, we currently do work in concert with U.S. Attorney's offices, both the Eastern and Western District, and we have for years and years have very good relations.
But Mr. Chairman,
Senator Edwards.
these cases you bring yourselves are under state law.
There are state statutes involved. There are federal statutes. It depends on the size of the case, the nature of the fraud that we are investigating, sir.
Okay.
Mr. Chairman.
Excuse me just one second. Delegate Rome, I don't know that any of your bills have to go to finance.
No, they don't.
We're only going to take care of the finance bills tonight.
Mr. Chairman.
I think Senator Servell still asking questions. and
This
then-
was on what you just said. A lot of House members are texting about whether they need to be here. Could you maybe read out the names
Okay.
of who will be here so we can
Sure.
foster some goodwill?
I'm sorry. House Bill 1550 from Delegate Campbell. House Bill 1636 from Delegate Boulevard. House Bill 1699 from Delegate Cherry. House Bill 1871 from Delegate P. Scott. House Bill 1892 from Ballard. House Bill 2208 from Delegate Kilgore.
So, Mr. Chairman, so if you're not Campbell, Boulevard, Cherry, Scott, Ballard, or Kilgore, we're not taking up your bills tonight.
That's correct.
Okay.
We've already done one from Delegate Campbell, and Delegate Orrock has this one, and then, but as I said, maybe before you got here, this will leave us with 26 bills, which means we'll start on Monday morning at 8 o'clock.
For you, 10 o'clock. Mr. Chairman, I have
I think that Senator Servell was still asking questions. Senator Edwards, Senator Servell, I apologize.
Sorry. Thank you, Mr. Chairman. The question for somebody. So my impression, I've never done a Medicaid fraud case, but my impression is they're largely financial. And so when we're talking about search warrants or subpoenas or whatever, we're talking about executing search warrants, usually on a doctor's office or some sort of medical provider's office. However, which I'm not as worried about because that's kind of a business premises thing. But I could also see a scenario where you're talking about executing a search warrant on somebody's home for their personal computer, their personal phone, their personal records. And there's been in order to execute a search on somebody's home, there's a significant amount of training that goes with that law enforcement goes through. And so, I mean, wouldn't you agree that this would authorize your agents right now to go into somebody's house with a search warrant to try to recover things that?
Mr. Chairman, to answer your question, Senator Surville, again, the scope and nature of the investigations would not change with this bill. It would simply allow the Medicaid fraud unit investigators that are so sworn to conduct those activities without having to partner with another law enforcement agency. And just to give a little background to some of the comments prior, the Virginia Medicaid Fraud Control Unit is being very successful over the years, a very high level of recoveries for the Commonwealth. This bill, we believe, would allow those recoveries to be more efficient. We have investigated fraud in the billions of dollars over the years, and the Medicaid Fraud Control Unit has operated without cost to the general fund of the Commonwealth since approximately 2008.
Mr. Chairman.
Senator Surville.
Thank you.
Mr. Chairman, may I ask Senator Surville for further response to that, because the early presentation of this bill, we had opposition from the Sheriff's Association, because at that juncture it was questionable, would they have to have all the same LEO training that your local deputies and everyone else has? They will. They will have to be a full-blown LEO with all other training requirements before they can do any of these powers.
Okay, thank you. Mr. Chairman.
Senator Surville.
But back to my original question, I think the answer was yes, that they could do a search warrant of a house. Would the patron I'm not sorry, I can't remember your name, but Mr. Childress, would you all consider a friendly amendment to say that that for any search warrant executed on a residence, that there has to be another sworn law enforcement officer present? I would think that's kind of a rare occurrence as opposed to a business premises.
Why?
Of course, whatever amendments the committee would think are well taken. I believe that the senator is correct that those instances are not as common, very rare. It's usually a business, it's usually a doctor's office, a clinic. But the investigations into those facilities oftentimes require the patients to be interviewed, and those interviews typically happen at the patient's houses, not a search warrant situation, but we do have many interactions with folks in their homes just currently.
Okay, thank you. Council, Mr. Chairman, have a motion?
Senator Surville.
Thank you. Could council prepare a motion to say that provided, add a qualifier to this bill that just says that any search warrant executed on the residence of any person, there has to be a regular sworn law enforcement officer present for that?
Mr. Chairman, yes, I think I would just say that they would need to be partnered with another law enforcement agency and have a sworn law. I'll second that. There.
Okay. Mr. Chairman, my question is why? I mean, if you make them a law enforcement officer, they can do it right then and there, right?
Well, in full disclosure, I mean, candidly, we want to try and get the bill through, and if that's what it takes to get through, there's a negotiated process. But secondly, I would suggest we're still kind of heading in the right direction, because we can always, if this isn't sufficient for them to do their duties, we can come back in a future year and take that out of the code and give them greater powers.
Does everybody understand the amendment? All in favor, say aye.
Aye.
Any opposed?
No, anyway,
Okay.
there's one.
The bill's amended. Are there others that want to speak to the bill in the audience?
Is any,
bill is
Mr. Chairman, any opposition? Okay.
The bill is
Move to
before the
report and
committee.
re-refer.
Okay. All in favor of reporting and re-referring? Are there other motions? All in favor of reporting and re-referring are going to vote yay. Please open the roll. Yeah.
Thank you, Mr. Chairman.
Ayes
Members of the
14,
committee.
noes 1.
Okay.
Have a good evening.
Who was first among the delegates? I want you to be honest.
There's some lawyers over here, come on.
Are you kidding?
I trust you. I trust you. Who was first? Boulevard, okay. 1636, Boulevard.
All right, thank you, Mr. Chairman. Members of the committee, this is House Bill 1636, and this was brought to me at the request of the Secretary of Education. Do have representatives from Department of Education here who can testify and answer any questions if you have them. What the bill does, it puts back in place penalties that were inadvertently removed for willful operation of a daycare facility without a license, where a child in that daycare facility is seriously injured or dies. Just some really brief history. So back in 2020, we consolidated early childhood and education programs from the Department of Social Services into the Department of Education. And so up until that point, this section of the code dealing with abuse and neglect of children included places like child daycare centers. However, when we did that consolidation, this section of the code was inadvertently narrowed by not including a reference to VDOE Title 22.1. And so as a result, the penalty only applies to facilities that were left in social services. So that includes child placing agencies, children's residential facilities, and independent foster homes. But because we didn't make that link to the new home of this, we lost that. And so this just
basically just cleans up a 2020 bill.
Correct, yes, sir.
Mr. Chairman,
Senator Obenshain.
unless there's a problem with this, I'd move to report and re-refer.
Is there any opposition? Okay, there's a motion to report and re-refer. It's been seconded. Are there another motion? If not, open the roll. A vote yea is a vote to report and re-refer. Okay.
All right.
Ayes 15, no zero.
Thank you, Mr. Chairman.
Who's next? Delegate Ballard, you've got 1892, I think.
Yes, sir, Mr. Chairman. House Bill 1892. Basically, if it pleases the committee, what I'd like to do is just tell you very briefly what it does, and then I have two witnesses here to give you the background information on it. I also passed out, prior to us going back over to the Capitol, a one-page fact sheet if you still have that in front of you. So basically, Mr. Chairman, members of the committee, House Bill 1892, what it does, it's designed to plug a gap in the current penalty structure for cases involving abduction of a minor. So currently, the way the penalty structure is worked is that it's a harsher penalty if you abduct a minor when there's intent for pecuniary gain, like a ransom case, intent to defile, or intent to traffic the victim. The problem that we found, and the witnesses will explain why we found it, is that when a stranger, and that's the key, a stranger steals a child, the maximum punishment is only 10 years. By comparison, if you would steal a car, the punishment is 20 years. So it's twice the punishment if you steal a car versus if you steal a child. Stated another way, stealing a kid is the same punishment as forging a check. So that really makes no sense whatsoever. And I want to point out that the goal of this bill, for those that are worried about the parental abduction cases, that's not what this does. This has nothing to do with parental kidnapping and issues that arise in custody disputes. We're talking about stranger abduction of a minor.
And stranger abduction, is that correct, that stranger abduction is limited to a 10-year penalty?
Mr. Chairman, it's class 5.
That's correct.
This bill would make it a class 2, Mr. Chairman.
Okay.
Mr. Chairman.
Senator Surville.
Thank you. I guess question of the patron, perhaps for council. I'm just trying to get a sense of how this works. I've never had one of these cases, but my concern with this was always, when patron had raised it with me, was whether or not this would come into play in custody cases where there is already an existing abduction statute. So I guess it's this, the language on 22 and 23, what you're doing is by pulling D out, it would not apply if the abduction is parental, but it could apply. Would it also apply to family members, like grandparent abduction or aunt, uncle?
Mr. Chairman, Senator Surville, I mean, the way it is worded, it does say on line 22, 23, except as provided in subsection D, and that does go into committed by a parent of the person. If the concern of the committee is grandparent abduction, we could certainly work that in there. I don't think that's the issue. And again, the witnesses can talk about this. This came about because it was a stranger abduction in Giles County. It was Senator Edwards' district, even Senator Deeds' district as well in Allegheny County. And so when they were looking at this and prosecuting the case, it was just kind of those weird one-offs where it's a true stranger abduction. This woman had no idea who this child was, literally went around to different churches searching for a child to steal and keep that child as her own forever and ever and ever. So it's not ransom, it's not one of those intent to defile cases, and the witnesses can speak to that. But to your concern, Senator Servell, if it's the pleasure of this committee, we could work in some language about that
So,
that
Mr.
issue.
Chairman.
I think, Mr.
Senator
Chairman,
Surville's got the floor.
So, Mr. Chairman, I think the solution to that would be to say, and counsel, correct me if I'm wrong, say something like, except as provided in subsection D, or if the accused is a family or household member as defined in 16.228,
well,
comma.
Mr. Chairman,
Senator Edwards, do you have
And
something?
that would mean, just so I'm clear, that would mean class 1 misdemeanor for parent, class 5 felony for family or household member, and then class 2 felony for stranger, which I think would make a lot more sense. Right.
you could also do another way around and say that abduction of a minor by a stranger or somebody that's unrelated to the child is class 2 felony, as opposed to going through, do it the other way. In other words, I think you could better, be easier to do it that way.
No, Mr. Chair, Mr. Chair,
Senator McClellan, do you have something to add to this?
yeah,
Something else, okay.
I think it's better to write it more tightly than just to say a stranger, because you could have someone, yeah, I read what you passed around, you could have someone who, if they are intentionally planning to do this, they could easily manipulate the situation so that they meet the child knows who they are, and they are no longer a stranger, but I think they would still count in the category of people you want to capture,
Yeah.
whereas family and household members aren't.
Yeah.
I would, Mr. Chair, I'd second Senator Serville's amendment.
Well, is the amendment just in concept, or do you have precise language?
I think we need to work on it.
I got pretty close, but I think Charles might be on it.
Charlie.
Mr. Chair, if I understand the amendment, I don't have any language in front of me, but it would be, just to repeat, it would be the class 1 misdemeanor for parent, class 5 for family or household member, and then class 2 for anyone who does not fit within those categories when it involves a minor.
Yeah, thank you.
Mr. Chair, and this,
Senator McClellan.
given the rise in sort of kinship custody arrangements, why would we want to make the penalty different for parents versus a grandparent or an aunt and uncle? I think they should be the same.
Yeah, I agree. I think Charles can come up with some.
Mr. Chair, if that was to be then the amendment, then it would be parent and/or family or household member would be the class 1, and then anyone else not in those categories would be the class 2.
Yeah, Mr. Chairman, Senator McClellan, I mean, I'm perfectly fine with that. Again, the main goal of this bill is to capture that kind of, odd situation where it's a stranger abduction. Right. So those, I appreciate those suggestions by the committee.
Mr. Chairman.
Senator Surville.
If we're going to go that route, then it seems to me that instead of it just being family or household member, it should be family or household member who is subject of a custody order of that child, or there needs to be some language that tightens it up so that that person has an actual entitlement, legal entitlement to custody or visitation of the child, as opposed to just any old random aunt or uncle that's out there gets the class 1 misdemeanor. Because I think that's the reason we make it a class 1 misdemeanor, because it's a custody dispute, not necessarily because of the relationship. And so it seems to me that if we're going to go that route, that was why I had the 3-part structure. But if we want to go this 2-part structure, I think there needs to be some clear entitlement to custody or visitation.
I think that makes sense. I think it makes sense if we agree to that amendment like that in concept. We decide to report it. It still has to go to finance, so we still have more time to look at it and figure out whether we got to have the language right.
I move the amendment in concept, and Charles can come up with
Which one?
Okay, we've got a motion and a second for a conceptual amendment that's based on what Surville
I
said.
thought it was McClellan said.
All in favor, say aye. Opposed, no. Okay.
Mr. Chairman, anybody objection to this bill?
Mr. Chairman, Senator Edwards, I did bring the prosecutor, the Commonwealth Attorney, and the investigator from Giles County. If you want to hear from them, I know they drove a long way to be in front of this committee, but that's certainly your discretion.
Well, they're welcome to come up here and give us a minute or two, but
I think we're probably fine, Mr. Chairman. If we're moving to report, we're probably in good posture.
report and re-refer to finance.
Hey, Bobby?
Okay, report and re-refer to finance. Is there another motion? Okay, open the roll. A green vote is a vote to report and re-refer.
Ayes 15, no zero.
Thank you, Mr. Chairman, members of the committee. Appreciate
Thank you
it.
very much. Okay. Who's next? 1699, Judiciary.
Mr. Chairman, how are you this fine evening?
We're good. Killing moves.
Killing and moving. Here we go. I am bringing you a bill this afternoon that was brought to me by my local police department. I was surprised, as have been pretty much everyone I've spoken to, when we realized that it is not a crime in the Commonwealth of Virginia to solicit for the purchase of a minor child. Only if you say you're going to do something bad to them does it become a crime. And I think it should be a crime just to try to buy someone else's child. Whether we're talking human trafficking, whether we're talking slavery, whatever we want to look at, I don't think trying to buy someone else's child should be okay.
Can I, and this, as I understand it, this arose out of a situation where somebody listed a child for sale on Craigslist.
It was an undercover sting operation, and our officer was working it. The defendant, the person they were trying to get, had offered to purchase the child.
Said it was his mother.
Yeah, it was a 14. Yeah, it was a 14-year-old he thought he was buying, but because he never said he was going to do anything nefarious with them, when he went to the Commonwealth Attorney and said, "What crime section am I charging them with?" he said, "It's not."
Let me. If it's a parent that's listing a child for sale, isn't the parent guilty of child neglect already? Probably felony child neglect.
Perhaps. But again, I think this is a loophole that we would want to close.
What's the felony child neglect situation? Yeah. But could you prove it a felony? Could you prove it a felony? Senator Serval's got something.
Thank you, Mr. Chairman. I don't have a problem with the intent of the bill. But the way I read it right now, I worry a little bit about an unintended consequence involving custody, visitation, litigation, and divorces. I mean, one of the things we do in Northern Virginia is the courts require equitable distribution and spousal support to be done in a separate hearing, separate apart from custody, so that parents don't start linking money matters with custody of the child. And the way this is worded right now, it says if you offer money custody at trial, you're in felony territory. And there's some parents in divorce litigation that start saying, well, if X on child support or X on a house, we'll give up on visitation. And I think this needs to have language in it, either needs to strike or custody, or it needs to have a clear exclusion for parents litigating visitation or custody.
Let me ask you.
Senator, I would see that as a friendly amendment. However, in testimony in the House side, that was brought up, and they said this was exclusionary of that. But I certainly understand if you see it differently.
Is there any evidence that this has occurred more than the one time in your situation?
From what we've understood, yes. And this was just the first time in a step of trying to get this fixed.
I think maybe a better way of doing this would be just to make clear in the felony neglect statute that this would qualify as child felony neglect.
Is there any case in Virginia on the subject matter? Does anybody know of any case law?
Senator Edwards, you got something.
Has any case law come about on the subject matter?
No, sir, because there's not a charge. There's not a charge on the books that they can charge them more. So the Code Section 18.2, 356.1, it literally lists a list of things that are wrong. And again, I think everybody, even the DLS lawyers in the courts of justice, were surprised that this is not a crime.
Yeah, Mr. Chair.
Senator McClellan.
I think the problem, though, is you may be able to charge a parent if a parent is trying to sell a child. But what about the person trying to buy the child?
That would be illegal as well.
This would cover both. Right, that's,
Yes,
I'm
yes.
saying I don't,
Oh.
I think the reason we need a separate, I'm being helpful. The reason we need a separate charge is because it's not just parents who are involved. And also, if someone entices a child, may or may not be kidnapping, that there is not related to that person, and then tries to sell them, we probably want to charge them too.
I agree with her.
Mr. Chairman, I mean, this requires an act in furtherance of.
Senator
That's-
Obenshain.
That's pretty aggravated conduct.
So it doesn't capture a parent who says, I'm going to sell you, or I'm going to give you whatever. You actually have to go take the money out of the bank or go collect and meet someone. So there is an act of furtherance as well, Senator, and I thank you for pointing that out.
Mr. Chairman, is anybody speaking,
What-
want to speak in favor of the bill?
What I'm wondering is, do you need an exception for a child custody case somewhere? Is that what Senator Servell was talking about?
It is, Mr. Chairman, and I believe there's a definition of code for a person with legitimate interest in section 20-124.1, and if those people were excluded as, where both parties or person with a legitimate interest is defined in 20-124.1, that would carve out the child custody situations. With people on both sides were that.
Would it carve out a situation where if, say, one parent agreed to pay all the expenses of raising their child in exchange for full custody?
Yes, it would cover that.
Surrogacy situation.
Yeah, that's surrogacy, that's different. So, Mr. Chairman, what the amendment would be, that, again, if you go look at 20-124.1 and it says person with legitimate interest, which defines who is entitled to file a child custody or visitation action. And so it seems to me if we excluded those people, if they're on both sides, that would solve it. And so maybe council come up with about 10 words to add that would pick that up.
I second it.
Okay, another conceptual amendment. Okay? And we can come up with something before we get to finance then. Okay? Does everybody understand the amendment? All in favor, say aye.
Aye.
Opposed, no? Okay. So the bills before you, are there people that you've got here ready to testify on this bill?
No, sir.
Are there people against the bill?
You like the bill? Okay.
Okay. Okay, there's been a motion to report and re-refer to finances. Are there other motions?
Which
You
one?
want-
This bill, Patrick Buchanan, Virginia Coalition Against Human Trafficking. This bill actually covers those scenarios where you have a pimp selling to pimp.
Yeah.
So there, at that point, there's no sexual conduct that has gone on. You're simply having to transfer from one pimp to another, and that's why we're in support of the bill.
Okay.
And we have that situation where person having custody or control, and that's what we're looking to.
We've had a motion to report and re-refer to finance. There are no other motions, so open the roll. A vote yea is a vote to report and re-refer. Okay.
Ayes
delegates.
15,
Thank you,
no
Mr. Chairman,
0.
members of the committee.
Okay, we're still in a killing mood. We got 3 delegates left. Delegate Scott.
Thank you, Mr. Chairman. I'll
1871.
take my chances with the committee here tonight. It's been a long day. I'm just going to cut right to the chase. This bill's a very simple bill. It extends the concealed handgun permit from 5 years to 10 years, also adds language to code that will allow a person to change any identifying information with the clerk, and the clerk will have to issue them a new card with that updated information.
Let me ask you, on the concealed carry permit, is it automatic if you apply for a concealed carry permit? And is there another background check done or anything like that?
So there's continuous monitoring that happens while you have a concealed handgun permit. So I have mine. It actually expires next month, and so I have to renew that. And so if anything pings, and so if you were to look at code 18.2-308.013, it talks about suspension and revocation of a concealed handgun permit. And so if anything happens during that time, it's automatically reported to the clerk's office. It's going to get suspended or revoked if any of that triggers. This does not change any of that. All it does is extend the time frame from 5 years to 10 years to reduce the burden on the local court system, also with the state police for background checks that have to be done every 10 years instead of every 5.
And it doesn't change the fee. You
Doesn't change the fee at all, nope.
okay. You still get double your time for the same money.
The fee is used to cover the administrative costs. So if they're only doing it one time, why would they have to charge double if they're doing the same thing? So we're not increasing the workload, we're reducing the workload, and then the fees are the same. They really don't make, it's not a money-making enterprise for the clerk's office to do this, nor is it for the state police. And so it's just reducing that burden on those different agencies.
Okay, are there questions for Delegate Scott?
Mr. Chairman.
Senator Surville.
Thank you. And patrons talking about this bill, which I appreciate that he came to me to talk about it. But I think he said that there's some kind of automatic notification that'll occur if there's convictions. But I believe there's a series of certifications that you have to make in order to get a concealed weapon permit where there would not be an automatic notification. For example, certifying that you're not habitually addicted to alcohol or drugs. And I think there's a few other things in the concealed weapon statute that that they might not be aware of during the re-up process unless the person themselves is certified to that. Am I imagining things, or is that right?
I would say that's still up to the individual. I mean, if I were to renew every 5 years or every 10 years, it's still up to me to make sure that I'm telling the truth. Now, me personally, I would, and I'm going to be honest. And the easy way to tell whether or not somebody is addicted to drugs or alcohol is if there's charges associated with such things habitually on their record. And so, again, it's not changing any of these other requirements, not changing any of the other restrictions or what's required to obtain it. They still have to go through the same process. We're not eliminating any classes or training they have to do. It's just extending from 5 years to 10 years, and then also allowing anybody to change any identifying information. If their hair color changes, mine is. Weight changes, mine has been. It's actually been going down this session. It's a plus. But I would be able to update that information. So.
I don't have any left.
So you'd be able to update yours, and they would have to issue. Right now, under Virginia code, the only allowance for updating personal information on concealed handgun permit is your name if you get married or change your name for other reasons, and your address if you move.
Any other questions? Senator Morrissey.
Good evening, Mr. Delegate Scott. This is similar to Senator Servo's question. It just seems intuitive that if somebody is going to get any type of license reinstated, whether it's a driver's license or a depot license, that there is some type of oversight by virtue of going up, getting that license, and the person or entity or agency that is issuing that license doing some type of check versus having a license that goes unchecked for a decade. For example, whether it is a violation of a protective order, the issue of a restraining order, a criminal charge, something that would prohibit you from having a gun and therefore having a concealed gun permit, it seems that would be caught. You would have that oversight by getting that license renewed after 5 years. Am I missing something, or isn't that true?
So, Mr. Chairman, to answer the senator, I'm not sure if I really understand, because again, there's automatic checks that are done through the state police, and if I commit a certain crime or a certain offense, it's automatically getting reported to the clerk's office, because my information is already in the system as being a concealed handgun permit owner, a carrier. And so I'm already in a certain classification of citizens with that. And there's additional responsibilities having that. And one of those is, hey, I'm going to say, yeah, I'm going to be part of this check system, and they can run this. And if I do something that's going to disqualify me, that gets reported automatically. That happens within 5 years, within 10 years. I'm not making this a lifetime concealed handgun permit. I'm just making it from 5 years to 10 years.
Follow-up question.
Senator Morrissey.
Do you have any indication of how many other states have a 10-year period where they have a concealed handgun permit?
Mr. Chairman, I would answer the senator. I have not done that research. And if there are none others, I think it would be a great opportunity for us to lead the charge.
Okay, Senator Stewart.
Mr. Chairman, just to provide a slightly different perspective with regard to what Senator Morrissey was saying and Senator Serval, if you have criminal charges or you violate a protective order, your right to possess is taken away from you. Generally speaking, this has no bearing on it. You otherwise have a constitutional right to carry a firearm if you're not prohibited for some other reason. What this section deals with is we give training, competency standards, little something extra for people who want to carry it concealed. And after they have that training and accomplish these competency standards, he's just saying let them keep it for 10 instead of 5 years. It has no bearing on those other things. It's completely apart from that.
Are there people in the audience who would like to be heard on this matter? People that are for?
Philip Van Cleve, VCDL. Yes, it indeed takes away a lot of the time the clerks are spending on this. It's, as mentioned earlier, it's not a profit thing for them. In fact, for them, some of it's a sacrifice. Thank you.
Thank you.
Yes, hello, I'm Portnoy Evans Johnson. I support the bill and VCDL.
Okay, thank you, ma'am. Okay, yes, next.
Good afternoon, Mr. Chairman, members of the committee. My name is Lori Haas, and I oppose the bill. The renewal process right now requires that the person send in a form with the mail with the check. That's a simple step.
Doesn't require an in-person appearance.
Correct. It's just mail in the form, re-up your application, re-up your renewal for your concealed handgun permit. It's a small fee, and I think we ought to keep it that way. The change to add a change of information makes sense, but the extending it to 10 years does not. Thank you.
Okay, thank you, ma'am. Are there others? Okay, the bill's before the committee. I think everybody understands it, don't we? Got a motion and a second to report. Are there other motions? Substitute motion. Move to PVI. Is there a second on that? Got a substitute motion and a second, and substitute motion takes precedence. Open the roll, vote yea as votes PBI.
Ayes 9, no 6.
Okay, thank you.
Thank you, Mr. Chairman.
Okay, got two more. Delegate Campbell and Delegate Kilgore. So whichever you is willing to take a chance. Okay, I see Delegate Campbell ambling up here. Delegate House Bill 1550. Do I have a motion?
Do I need to explain?
Please explain, Bill.
Mr. Chairman, members of the committee, this bill, I'm going to be honest with you, as you get older, and every day I sit up here, I get older and older and older. So it was on my bucket list when I came up here. So for 20-some years, I was on the opposite side of these cases. And we're talking about administrative investigations of child abuse cases involving teachers. And as we all know, public school teachers have a vested property right. It's protected by the Fifth Amendment, and they cannot be deprived of that without due process of law, a hearing, a notice, an opportunity to be heard. And the administrative investigation that DSS undertakes is, in front of a hearing officer, is of a limited due process. The hearing officer has the discretion to deny access to witnesses, to allow voluminous hearsay in the proceeding, and ultimately, I know I've got one friend down here on the confrontation clause. A lot of times those complaining witnesses are not even allowed to be cross-examined by the counsel for the teacher. So I honestly thought at some point in my career I'd be across the street, on that proceeding at the Supreme Court about this, because there's no question that it's a violation of due process. And all our bill does is it allows for a teacher who has been the subject of a finding of abuse and neglect to, in the alternative, ask the circuit court for a trial de novo, where they will have the full panoply of due process available to them, the right to be able to call witnesses, to confront and cross-examine complaining witnesses, to be able to defend themselves.
This is after they exhaust whatever administrative appeals are available?
That's correct.
Okay, and what is the process in a
So
case like
currently, if DSS investigates and the CPS worker founds the case, then they have a right to be able to ask for a local conference in front of a director of the Department of Social Services, and then the director can make a determination based on the evidence that's been developed, whether to uphold the finding or not. If, in fact, the director's finding is upheld, then the next step in the process is under the Administrative Process Act currently, which is a petition to the circuit court. But the standard there is only whether there's substantial evidence in the record to support the finding. The judge isn't taking evidence. There's but no question that this violates due process, I think. And what this bill will do is it will allow that teacher to avail themselves of that due process. And it's important because a finding is tantamount to a loss of their career. They cannot work anywhere else once that finding's put in place. So I think they have the right to avail themselves of that. This, I will tell you up front, and it may move the needle one way or the other depending on how you feel about this, but VEA is in full support of this.
Chairman, I was seeing the VEA nod
Senator
vigorously in the back, and this represents my opportunity this year to actually side with the VEA on an issue.
Right,
This is a red letter day.
Senator Boysko.
Mr. Chair, question for Delegate Cable. So you said that this has been on your bucket list. You've been hoping to you've had trouble with this in the past? You've carried this and it didn't go through?
No. I'm saying it was on my bucket list to do this during the time period that I was up here. And,
You've just
and
never-
I'm at that point where I
Okay.
decided it's time to put the bill in.
Thank you. I just was confused. I couldn't understand why it would be controversial at all.
Senator Morrissey's got questions.
First of all, I'll tell you, Delegate, you had me with when you said I'm here to support HB 1550. My only question is this. What about other D-POR licenses? Do they have that avenue of review with a court of record that you're seeking for teachers? My only thought when you were reciting this is not only am I with you 100%, but what other people are not being able to avail themselves of an appeal to a court of record? Because you're right. Sometimes it's already lined up against you. They know what they're going to do before you even go in there. And you're right. It's a complete and total and utter violation of due process.
Right. So, and Senator Morrissey, to coin the phrase of my good friend from Scott County,
Get your own
bill. Right.
I mean, this is a lawyer's bill. It's a good idea. The question is, how do you cut off the faucet once you open it up?
Mr. Chairman, I have a friendly suggestion. No, it's down here. I noticed that in the new but struck out language, the language at line 467, it included within 30 days of the aggrieved person's receipt of the hearing officer's decision, but that clause is not picked up in the new language at 471. And I imagine the patron would want that language in there so you have a definite period. The question otherwise is filed within 30 days of what?
It would be within 30 days of the receipt of notice of the decision.
So moved, Mr. Chairman.
Okay, does everybody understand the amendment? All in favor, say aye. Opposed? No. Okay, are there people here that are compelled to speak to this bill?
I'm not sure.
We understand you're for it, that's all right.
I like to hear what VEA says.
Thank you. Thank you, Mr. Chairman. Shane Riddle with the Virginia Education Association. For the record, we do support the bill, and we appreciate the patron
Okay, thank you.
sponsor.
Okay.
Thank you.
Are there other thoughts on the committee? Are there motions?
Move to
Mr.
report.
Chairman, the question I have,
Okay, Senator Edwards has a question.
this question has to do with child abuse and neglect. Is that the,
When a teacher gets charged.
yeah, the teacher is charged with committing child abuse and neglect. That's the issue, right?
That's the issue. As they're in the class of persons statutorily that are custodians of children and are subject to those administrative investigations.
But that's limited to that issue.
Exactly.
Okay.
Okay, Senator Boysko's got a motion to report and re-refer. Is there a second? Second. Are there other motions? Okay, open the roll. Green vote is a vote to report and re-refer. Okay. Delegate Kilgore,
Ayes 15, no zero.
you're next.
Thank you.
Thank you. 2208.
Yes, this is the anti-Semitism bill that I think you all have with Delegate Reeves, I believe, Mr. Chairman.
Mr. Chair.
Delegate McClellan, or Senator McClellan, I apologize.
Is this, would you be okay conforming this?
Yes.
Okay, move to conform to
Yes.
Senate Bill 1184.
Yeah, at this time, I'm
Okay.
fine.
Senator McClellan has moved to conform the bill to the House, to the Senate bill.
Yeah.
Is there a second?
Second.
Okay.
And that passed.
All in favor, say aye. Any opposed?
And Mr. Chair,
So we have the conform bill in front of us.
which passed the Senate unanimously, so I
Yeah.
move that we report and re-refer to finance.
Okay, there's a motion to report.
I'm gonna try to just get this.
The motion is to report and re-refer to finance.
I have a question about the bill. Is this like the other bill we had?
We just conformed it to
I
that,
know,
yes.
Mr.
It
Chair,
is
now
now.
it would be. It's identical, it'll be identical to the Senator Reed's bill.
Identical to the bill we sent out here unanimously.
Said, no, it wasn't, I voted against it. I'm pretty sure.
Well, there was a bill we voted against.
The bill that we conformed is the one that went out of here with no dissenting votes.
Okay, so the motion is to report and re-refer,
I'd like to see the bill, actually.
1184.
Just let the vote know, John. Let's vote, let John vote no.
I'd like to see the damn bill, okay? If you don't mind. 11 where? What's it called? What's it?
1184.
Mine was 2208, but the Senate bill was Senator Reeves, which was, I had it here somewhere, 11.
That's all, okay. All right, okay, yeah. Okay, I think I know what it is.
Okay.
Please open the roll of vote. Yea is a vote to report and re-refer the conform bill. Okay, we'll do it Monday.
Ayes 13, no zero.
Thank you, Mr. Chairman.
Okay, thank you so much.
All right.
We have, as I said, we have 26 bills left. We'll meet on Monday morning at 8:30, and we'll get rid of bills, we'll get them passed before we go to caucus, or we'll leave them on the table. And the world won't end either way.
Adjourn?
8 o'clock Monday. 8 o'clock. I'm doing it at 8 o'clock for a better chance to get up.
Yeah,